What about the Yout v. RIAA appeal? Yeah, sure. Let's check out what's going on with Yout v. RIAA. They lost, of course. They did not have to pay attorney's fees. And then where's the appeal? Second Circuit, here we go. Notice of Civil Appeal, October 25th. Okay. Recording industry. Yout. Oh, now I gotta sneeze. So we've got 25 pages just to get through the facts. And then the 25th page is summary of the argument. And then there's another many pages of argument. Let's just look at their headings. No decryption, descrambling is necessary. Okay, so we're not doing that. The motion to dismiss standard of review and how they, I guess, pass the test. The district court recognized the distinction between access control and copy control. It proceeded on the access control issue instead. Whether there is even a technological measure is a disputed question of fact, not susceptible to resolution on a 12b6 motion. Okay, so that would mean it should survive a motion to dismiss. Yout did not violate 1201A1. Yout could not have violated the access control provisions. So they're attacking the judge's analysis, that the judge used the wrong analysis and misconstrued the facts. And then, of course, there's going to be 92 pages of supporting that. The fact that the copyright holders here did not themselves employ any technological measures, instead relying on technology used by a third party, which may or may not be designed to prevent copying, the works at issue are made freely available to any person in the world with a connection to the internet and a web browser, and there are no technological measures that effectively prevent the access or copying of the works at issue, with or without the use of plaintiff services. So they're arguing that the judge misconstrued the law and the facts by granting a motion to dismiss when there was a legal claim that could lead to relief or shouldn't have granted YouTube's, or the RIAA's, excuse me, the RIAA's motion to dismiss. Let's go back to here and see where it is now. So you've got the brief on February 2nd, and then you've got the RIAA's brief was just filed on May 4th. Their table of contents says, it talks about the purpose of the DMCA and its anti-circumvention provisions, and that the streaming market for copyrighted works depends on robust enforcement of the DMCA. Yout acknowledges that the YouTube video player is limited only to streaming. Yout's complaint details a complicated set of steps to download a video and music files from YouTube. Okay. Yout's allegations make clear YouTube employs a signature mechanism and Yout bypasses it. Let's see what page 16 says here. That Yout's technology is used for circumvention is clear from its own allegations. Yout concedes there is technology at play when an individual visits the YouTube website to watch a video. That's their first argument, okay, in this section. According to Yout, the YouTube technology includes a signature mechanism, which Yout describes as referred to by the RIAA as a rolling cipher. Is a rolling cipher technology that effectively controls access to a copyrighted work? I don't know, it doesn't seem very effective to me. When a user visits a YouTube video, YouTube servers send a JavaScript program embedded in the YouTube video player to the user's web browser. That program calculates a number, the signature value, which then forms part of the URL that the user's browser sends back to YouTube to request the actual video stream. Yout alleges how to identify this signature value. It is the numbers following the text range. Yout then alleges that this range must be modified to access and download the video and audio files. In other words, a user cannot download a video on YouTube without bypassing the signature mechanism by changing the YouTube-assigned signature value. Are they really arguing that changing a parameter value in a, I'm guessing, HTTP GET request is breaking encryption, is bypassing effective technological protection measures that control access to a copyrighted work? It's an argument. Critically, as the district court explained, the fact that Yout alleges that a signature value must be modified to gain access to the downloadable file leads to only one plausible conclusion, that otherwise that file would be restricted. Can anyone tell me, is it a GET request? Because I've always loved this argument. You know, if the way HTTP works, you know, if I request some resource that I'm not supposed to have access to, and you give me access to that resource, like, what did I do wrong? I knocked on the door and said, could you give me $100 that I'm not entitled to? And you said, okay, here's $100. And then you went and said, hey, you weren't supposed to ask. That's legal. Like, you could ask somebody for $100. Like, it might be annoying. You might not necessarily be in everyone's favor if you went around knocking on doors asking for $100. But if you knocked on someone's door and you said, could I have $100? And they gave you $100, and then you walked away and they called the police. You took $100 from me. You asked and I gave you $100, and you shouldn't have been able to do that. What's the problem? So here we have something similar in my eyes with Yout, where they are getting, they are somehow getting a URL with a rolling cipher, and then they are simply changing the rolling cipher and then requesting the same URL. Whether that is bypassing a technological protection measure that effectively controls access to a copyrighted work, or whether that's just an identification mechanism so that YouTube can serve you sort of a second factor authentication or some sort of tracking identification that you've been authorized to receive this stream. If you're unauthorized to receive the stream, though, is it copyright infringement if you receive the stream? I don't think so. If you receive the stream, I think it's maybe a breach of YouTube's terms of service. YouTube might be able to come after Yout for that, but that's not what's happening here. It's Yout going after the RIAA because the RIAA came after Yout's, I think it was GitHub repository. I get it. It's a problem. They don't want you to be able to time shift content. And of course, you're doing more than just time shifting content, in my opinion. You're on demand, grabbing something and then keeping it for yourself, like a copy. It's not a streaming service where you're recording something off of a stream. Yeah, I don't know how these things really translate to the modern world. How does Sony, is it Betamax? I forget who the plaintiff was, but the Sony Betamax case where they were sued for time shifting, allowing you to record live TV broadcasts and then watch them later, and that they sold a device that allowed it. They didn't do the time shifting for you. That's illegal and still illegal to this day. But you can record off of the air and then play it back for yourself later. You can't share it to the internet legally. You can't sell it to someone. Not even sure you can legally, technically give away your time-shifted copy. I don't think anyone's going to come after you, for giving away a one-off copy, but, technically not legal. It's for your home use, your personal use, and it's just for time shifting. So what about today? What if I go to a real radio broadcast live stream, over the air, and I record that for myself and I play it back for myself? Probably okay. But what if I go to a video on demand and I play that back and I record that so I can have a copy offline? That crosses the line. That's not legal like the Sony Betamax case. It was legal. That hasn't been tested, and I'm pretty sure if it was tested, it would fail. And you would not be allowed legally to rip video on demand content that the service does not want you downloading in the first place. Like you can pay for YouTube Premium and you can download the thing, but it's still controlled by YouTube's app and service and all that. They don't want you to have a free, as in free as in speech, copy of as in it has its freedom to the world. There's no consequences. There's no DRM. There's no. They don't want you to have that free file. And at some point they're allowed to do that, and at some point they're not. And so this is the dispute here. Is Yout allowed to make a product like a Sony Betamax tape deck that allows you to time shift content by downloading it for offline use? I use Stream Rippers for occasionally making fair uses of videos. And somebody could come after me like they tried to come after H3H3. So where is the line? Am I allowed to make a tool that that does stream ripping, but otherwise not promote illegal stream ripping. And that's what the dispute is here. Yout undermines the market. The RIAA has to send takedown notices. Stream rippers violate anti-piracy laws, I guess, in other cases. Courts have reached the same conclusion in other cases. We'd have to read through each of these cases as well. Yout filed this lawsuit seeking a declaration that it did not violate Section 1201. Yout conspicuously failed to plead any details about how YouTube or Yout's service works. Yeah, that is, it's also the problem, like you pointed out in their brief. So you've got the RIAA trying to enforce the anti-circumvention parts of Section 1201 against Yout, but the anti-circumvention provision or technology is YouTube's, not the RIAA's. But it's maybe not written so specifically that it has to be my technology that you breach in order to breach my copyright. So yeah, that's Yout is the plaintiff. Yout filed sort of an offensive pleading to take control after the RIAA had gone out of court on the attack. I believe they had sent a takedown notice or legal threat or something to Yout or to GitHub for hosting Yout, I think it was. And I think GitHub had come out in favor of Yout and decided to keep it up on the platform. The whatever Yout's download service was, I think. This was 2 years ago, I think. And now Yout has lost on a motion to dismiss. Yes, it was October 25th, 2020. And Yout lost on the motion to dismiss, meaning the RIAA got rid of their lawsuit. And so Yout is now trying to revive the lawsuit in appeals court. Being that you can set up Media Player to directly play streams from sites like Twitch, YouTube, VODs, and you can save video on demand from YouTube directly, am I missing a line that a stream ripping service is crossing? Yes, it's the difference between the ones that YouTube authorizes and the ones that are not authorized. Certainly authorized ones are not going to be unauthorized and are not going to be in dispute, but it's the unauthorized ones that we're curious about. If you have a Spotify account and Spotify lets you download for offline use, or you have a YouTube Premium account and YouTube lets you download for offline viewing, or any one of these other services, streaming services that lets you download, that's the terms of service and the features of the app. Those are all authorized ways to do it. If you want to watch your videos on a plane and you don't use the services download button, or your service doesn't offer a download button, so you go and get some third-party tool to download or record your screen or whatever. This is a chore. This often takes multiple vectors to try to figure out. I went to take a screenshot of the Lord of the Rings, Rings of Power dragon scene for that thumbnail, and my screenshot software was detected and the screen was blanked out and I couldn't get a picture, so I had to find a different way to do it. And I'm not going to tell you how I did it. But you often have to cross the lines or come right up to the line of copyright infringement in order to figure out how to get a download from a site that doesn't let you download. So those unauthorized downloads are what's at issue in this Yout case. Is it legal for them to provide the software? And this isn't a ruling saying it's not legal, but it isn't a ruling saying it is legal either. It's not the declaratory judgment of non-infringement that they wanted. So, if you use YouTube's download service, button, and it's in-app and all that, that's going to be perfectly fine. If YouTube has a partnership with some other app or service that lets you download, that's fine. But the ones that are not authorized, I don't know if that's legally permissible or not. YouTube might not authorize it, but it might still be legal under fair use or time shifting, Sony Betamax or something. But it's also not clear, and so that dispute still has to be had. For YouTube, I do not mean a premium account, but rather you can obtain a direct backend link to the YouTube video, plug it into any browser, and you'll have the raw video file of the upload that you can right-click and save as. Yes, Sweet Jackal, I agree with you, and I think that was the rolling code cipher discussion above. The RIAA is trying to say that that process includes some kind of recognizable technological protection measure that counts for copyright Section 1201 purposes. And Yout is trying to say what you said. Wait, there's nothing this complicated. We're just processing a URL and asking YouTube for the video file, and then they send the video file. Dan, RIAA used the same arguments here against YouTube DL. Could Yout persuasively cite this EFF response? Let's take a look at the EFF response. So what did the RIAA have to say? Dan, thank you for the link. Who's writing this first? Let's see here. This is Mitch Stoltz. I know Mr. Stoltz, at least professionally. The Electronic Frontier Foundation represents the current maintainers of the YouTube DL software utility, a free software project that uses GitHub as a home. Okay, so this sounds familiar. We write to thank GitHub for striving to protect the rights of free and open source software, etc. YouTube DL's maintainers are replacing references to the copyrighted works. I remember this one. There were 3 test downloads that were to RIAA works, and the RIAA did not like that. Second, YouTube DL does not violate Section 1201 of the DMCA because it does not circumvent any technological protection measures on YouTube videos. Similarly, the signature or rolling cipher mechanism employed by YouTube does not prevent copying of videos. Below, we explain each of these points in detail. Yes, thank you, Dan. This is very on point. So, yes, I would expect that Yout would use these same arguments. You might find them in their brief as well. YouTube DL is a command line utility for streaming and downloading user-uploaded videos from various websites, including YouTube. The RIAA's letter refers to a single file of YouTube DL's source code, which references several copyrighted songs. We got that. The signature code. For a subset of videos, YouTube employs a mechanism it calls a signature. When a user requests certain YouTube videos, YouTube's servers send a small JavaScript program to the user's browser embedded in the YouTube player page. That program calculates a number referred to as a sig. That number then forms part of the URL that the user's browser sends back to YouTube to request the actual video stream. This mechanism is completely visible to the user simply by viewing the source code of the player page. The video stream is not encrypted, and no secret knowledge is required to access the video stream. JavaScript is an ubiquitous technology found on millions of websites and understandable by numerous software programs. Any software capable of running JavaScript code can derive the URL. To borrow an analogy from literature, travelers come upon a door that has writing in a foreign language. When translated, this writing says, "Say friend and enter." The travelers say friend, and the door opens. As with the writing on the door, YouTube presents instructions on accessing video streams to everyone who comes asking for it. I still like my HTTP GET request analogy, which might not be the analogy. It might not be the way it might be the way it operates, which I think really just does away with this argument right away in favor of Yout and in favor of YouTube DL. YouTube DL works the same way as a browser. When it encounters a signature mechanism, it reads and interprets the JavaScript program, derives a signature, and sends back that value to YouTube to initiate the video stream. YouTube DL contains no password, key, or other secret knowledge. So yeah, it's either a rolling cipher if you're on the side of the RIAA, or it is some sort of tracking or identification value served by YouTube upon every video request, but served willingly and voluntarily and not surreptitiously obtained or something. YouTube DL does not violate 1201B because signature code does not prevent, restrict, or otherwise limit the exercise of a right of a copyright owner. Then they refer to the 2017 decision of the Hamburg, I remember this, we've covered this, Hamburg Regional Court in Germany that the RIAA references refers to YouTube's signature mechanism, but was wrongly decided and is not binding under U.S. law. The court in that case apparently reasoned that since the judge was not familiar with JavaScript, using the signature code was beyond the capabilities of the average user. It was on this basis that the court declared the code to be an effective technological measure. The court's analysis overlooks the ubiquity of JavaScript, which is really easy to use. YouTube DL does not violate. Mitch Stoltz. Got it. Yeah. So yeah, I agree with you, Dan. GitHub and EFF also wrote amici briefs for this specific Yout versus RIAA case. Do I need a link? No, they would have had to file them either in the appeals part. Let's see. Yep, here we go. New party, EFF. Amicus Brief, EFF. Here, let's get a copy. Yes, I don't want to tell you my password. Let's get a copy of that, and I'll pay for it so that you guys can have it too. So everyone can have 22 pages, $2.20. Jeez. Spend money on you. So this is the brief of the EFF, and they're going to argue, I'm going to guess, something very similar. These programs fulfill the same function that video cassette recorders once did. They enable ordinary people to make and retain copies of videos that have already been released to the world at large by their creators. Like every reproduction technology, from the printing press to the smartphone, these programs, colloquially called stream rippers, have important lawful uses as well as infringing ones. Video creators, educators, journalists, and human rights organizations all depend on the ability to make copies of user-uploaded videos. Copyright law ordinarily protects and promotes the lawful activities of these groups through the fair use doctrine. But overbroad application of 1201 effectively strips that protection away, making these lawful activities legally fraught and practically difficult in the digital age. The RIAA and its member companies are engaged in a campaign to make stream ripping tools a contraband technology unavailable even to lawful users. Over the past several years, they have sought to block, censor, and demonetize providers of these tools because a subset of their users infringe copyright. The RIAA asserts that stream rippers necessarily circumvent access controls on video sharing sites like YouTube in violation of Section 1201, a position adopted by the district court in this case. That position is wrong. The district court adopted an extremely broad construction of a technological measure that effectively controls access to a work that is not supported by statutory text or precedent. The district court's holding effectively applies the strictures of Section 1201 to any copy of a work in digital form, not just the subset that rights holders have chosen to protect with technological means. Because the exceptions of 1201 are narrower and more conditional than the exceptions to copyright itself, the district court's holding would increase legal and practical impediments to many lawful and important uses. That result would be contrary to copyright's constitutional purpose to promote the progress of science. This court should take a different approach. Text, legislative history, and precedent suggest clear limits on the definition of technological measures. So, what are we fighting? The prohibition to certain technological measures used with copyrighted works. These prohibitions, you cannot break encryption or technological measures that effectively control access to a copyrighted work. Subsection B applies to measures that effectively protect the right of a copyright owner in a work. The statutory language places an important limit on the scope of technological measures. It includes only technologies that were actually intended for use as controls on access or copying. A computer program or other technology can impede access to a creative work, but only one that was installed for that purpose is a technological measure. So I'm going to guess he's going to say, or the EFF is going to say, that YouTube's cipher or YouTube's rolling code or YouTube's signature parameter is not created for that purpose. The YouTube website code at issue was not clearly designed to limit access to videos or the ability to copy them. YouTube videos arrive at a viewer's device with no encryption or scrambling. No login, password, key, or other secret knowledge is required to gain access. When a user requests a YouTube video using a web browser, YouTube servers send a web page which contains a JavaScript program. The program appears to have several functions, including selecting the video quality that the user's internet connection can support and selecting the starting point for playback, the range function. The program also generates a signature value that is passed back to YouTube's servers to initiate the video stream. The program is not secret. Any member of the public can read it by simply right-clicking on the web page, and any common web browser can run it. While Defendant Appellee RIAA described this program as a rolling cipher, the program does not limit any user's access to videos or their ability to save a copy. YouTube does not identify the player program as an access control. The district court cited to language in YouTube's terms of service asserting that users are not allowed to circumvent features that limit the use of the service or content, but those terms don't state or imply that any feature of the service, including the player program, is intended to prevent downloading. Tellingly, YouTube does use encryption and a password-controlled login to limit access to subscribers of its separate pay TV service, YouTube TV. That similar access controls are not present on YouTube's core user-uploaded video platform is another indication the company did not intend to impose an access control on user-uploaded videos. The absence of a downloading button does not transform anything. The district court's unbounded definition of a technological measure would impede future uses. If technological measures can be identified retroactively in litigation without clear indicia that an access control was intended, then almost any work distributed in digital form could later be deemed subject to the circumvention ban. And any tool that automates or otherwise enhances access to such content risks liability. On some level, they're allowed to protect their works. On some other level, why is the RIAA arguing that YouTube's rolling code signature is a technological protection measure enough to prevent access to copyrighted works? I can see both sides, but it's really frustrating because I don't think anything bad is really going on with people being able to download. If you couldn't download using YouTube DL or using Yout or whatever, you would download using some other tool, screen capture or something like that. And what would they do then? They'd tell you can't capture your screen. No, there's obviously a limit here, and I think the limit is user-initiated downloads are okay. If someone is doing the downloading for you, if I'm a third party and I'm the one doing the downloading and then serving YouTube's video on demand content from my servers and serving my ads, and you're paying a subscription fee to me, that's obviously illegal. That's the line for copyright infringement. We're trying to prevent other people from getting free copies and being able to sell them or distribute them themselves. And yes, there are lots of tools that can be used for that, and you shouldn't take away the tools that are used illegally when they are primarily used for the authorized or legal things, and they're not specifically marketed for illegal or legal activity. It's just like saying, you can use your car for good or bad things, so we should take cars away from everyone because some people use them improperly. And that's where I fall on that argument is you should be able to access, downloads of YouTube videos and things using, YouTube DL or whatever. If YouTube wants to stop it, they can implement technological measures to stop it. And they didn't. They haven't implemented technological measures to stop it. So I am on Yout's side, YouTube DL's side, the EFF's side, not the RIAA side. Let me know what you think. So let's say you're at a bakery that's giving away free pie, and all you have to do is there's advertisements on the side of the building. So you walk up and you see the pie stand and the advertisements, and there's you walk up and you say, "Hey, I want a pie," and they say, "Okay, tell me this code 1 2 3 4 5," and then you go, "Okay, I want a pie 1 2 3 4 5," and they give you a pie and you walk away. Is that a technological protection measure that effectively controls access to a pie? I mean, it's so simplistic. I guess if you didn't say the 1 2 3 4 5, and the rule is you don't get a pie unless you say it, but the instructions came with it. How is that a protection measure? Do protection measures usually tell you how to bypass them? In the protection measure? No. The protection measure in this case, the alleged protection measure literally tells you, here's the code. Anytime you give me this code, I'm going to serve you a pie. So you can give it to me from Chrome, or you can give it to me from an app, or you can give it to me from YouTube DL, or you can give it to me from this or that. But I'm going to serve you when you give me that code and request this pie, I'll give you this pie. That the instructions are in the measure. It's not a protection measure. Sure, you could call it technological. You could call it some kind of measure, but it's not a protection measure. I think it's some kind of identification measure. And it doesn't matter what it's for if it's not an effective measure. So it's an ineffective protection measure. If it's meant to be a protection measure, it's ineffective. And if it's not a protection measure, then it's not a protection measure. That's my opinion.